Welcome to Oregon Legal Center's video series on estate planning. I'm Richard Noble, and the topic of this video is what is probate and how can I avoid it? People often ask, what is probate? It's something they kind of instinctively know they want to avoid because they've heard about how expensive it is and how time-consuming it is, but they really don't understand what it is and why they would have to go through it. Probate is the way our legal system deals with the transfer of assets. It's a system where the probate court, and there's a probate court in every county in Oregon, where the probate court actually supervises the transfer of your assets to the next generation. People will ask, well, I have a will. Doesn't that mean that I'm not going to have to go through probate? Well, that's a common misconception because whether you have a will or not has really nothing to do with whether you go through probate. Where people get into probate is where you've selected somebody, say in your will, to be your personal representative, or sometimes they call that job executor. And you think, well, this person I've named is the one who's going to be in charge of my affairs, and they'll be able to wind everything up and distribute my assets to my children. But what people don't understand is really when they do a will and they name somebody to be the personal representative, really all they're doing is just nominating that person to be the personal representative. The person really isn't the personal representative and can only become the personal representative when he or she is approved by the probate court. Now, how does that happen? Well, just imagine, for instance, that you have a bank account at a bank that you own, and you have a will that says that I leave all my assets to my children, and you're thinking that the person you've named in the will is going to go to the bank and going to somehow close the account out and distribute the money in your account to your children. What would happen if your personal representative would go to the bank and try and do that? Well, he or she immediately would be met by resistance at the bank. They really aren't going to deal with anybody except you. Your personal representative could explain that you passed away, that you did a will, that he is named as the personal representative, but the bank official is going to tell him that really he better go see a lawyer because he's not really the personal representative just because he's named in the will. And your personal representative would go to an attorney and he'd quickly explain to him, well, no, you're not the personal representative yet. We have to file some papers in court. We have to file the will in court. We have to ask that the judge appoint you as the personal representative. And I'd be glad to do that for you. We charge by the hour here to do that, he would say. And of course, we're not going to get paid till the end. We're going to keep track of our time. And that's the beginning of this probate process. The person you picked would probably be appointed unless there was some problem with that person, say bankruptcy in their background or something that would disqualify them from being the personal representative. They'd get some papers back called letters testamentary, which then, if they took those letters testamentary over to the bank and showed them to the bank then would be more than happy to let them do whatever they wanted to do with that account, just as if they were you. They would be substituted for you in the eyes of the bank. Well, all well and good. The personal representative gets access to the account, but there are many rules in place, many hurdles that the personal representative has to jump over before this probate process is completed. And to navigate all these rules, the personal representative is going to have to make extensive use of the attorney who is going to be keeping track of his time. Typically, attorney fees for probates can range anywhere from $5,000 to and up. I mean, maybe up into $15,000 or even more than that, depending on legal issues that come up during the course of the probate administration. So your personal representative will have to just follow the lead of the lawyer, go through all these steps, and finally at the very end of all this proceeding, which probably is going to take close to a year, finally he will get permission from the judge to make a distribution to the people that you named in your will who are going to get your property. So for many reasons, people aren't really thrilled about going through probate. They don't like to have to pay the attorney fees. They don't like the long delays that the probate process imposes on the procedure. These delays are designed to give everybody fair access to your assets. They want to make sure that everybody has sufficient time. And by everybody, I mean the state of Oregon, the U.S. government, taxing authorities, Medicaid, lien holders, other creditors, people who you may have left out of your will who may assert some claim to the assets. It's a very fair system, and it's designed to give everybody plenty of time to make objections if they have objections. And that's kind of the main reason why everything gets so drawn out in probate. Plus, you have to file all these papers in court, and that just takes a lot of time, too, just to process everything through the court system. So the reason you get into probate is because the person you've picked to be in charge of your estate under your will finds out very early on that they aren't going to get any cooperation from any of these third parties like banks, brokerage houses, other financial institutions, title companies if they want to sell real estate. Your person representative is going to be met with kind of this negativity that will force them to go see an attorney and get involved in the probate process. So that's sort of a brief explanation of what probate is and how how it works. There are other topics in this video series that go into ways that you can, other things you can do other than a will to avoid probate. And the key thing you can do to avoid probate is instead of using a will, you use a living trust which would take the place of the will and would actually specify who's going to get the property that you've put into the trust. And again, there's another video in the series specifically on living trusts, which will talk about all these various issues. Well, thank you very much for listening to this video, watching this video, and we hope to see you at Oregon Legal Center.